for civil rights with the DOJ and a lifelong civil rights lawyer. So it's wonderful to continue the conversation today with our wonderful panelists. And I am going to start by asking them to each introduce themselves and to include a brief overview of their professional path to date and what they do for their current organizations. And I think for simplicity's sake, we'll just go in alpha order and begin with Jim for Kadima at Lambda Legal.
Hey folks, I'm Jim for Kadima. My pronouns are he, him, L, and two. I have spent the last 20 years being a public interest lawyer, both on the advocacy side at high impact legal organizations, as well as 10 years in government at city, state, and federal level. At present, I am with Lambda Legal, and I'm one of 3 legal deputies. And most of my work is most of the housekeeping, ethics, general counsel, all the rules you have to comply with in national cross-country litigation. I get to be the wrangler and keeper of all of those fun tasks to keep us on track to stay compliant as a law firm, albeit a public interest law firm. But prior to that, I have done federal policy shaping in the final years of the Obama administration at the U.S. Department of Education for many of our civil rights laws. I've also been in a general counsel, an associate general counsel for policing oversight at the city level in Chicago in the wake of the Laquan McDonald shooting scandal and withholding of that video evidence. And I've also been a quasi-judge adjudicating cases for Illinois' Human Rights Commission prior to moving back to DC for Lambda Legal. Yeah, so most of my career has been in pushing government or making decisions within government, and happy to make time and answer questions today. With that, I will pass it back for the next person.
Wonderful, thank you, Jim. And now move on to Erin Martin with National Women's Law Center.
Good morning. Oh, good afternoon, everyone. It's afternoon. Nice to meet all of you. I'm Erin Martin, pronouns she, her, hers, with the National Women's Law Center. So I also have worked in public interest for the extent of my legal career since I graduated from law school. I did a little bit of litigation, impact litigation work through my fellowship when I started out my career focusing on economic justice issues. And then I joined the Justice Department where I also worked on litigation. And then I've been doing policy advocacy for about the last 4.5 years or so. I was at the Lawyers Committee for Civil Rights Under Law as a policy counsel, where I worked on judicial and executive nominations, education policy issues, and privacy and technology. And in my current role at the National Women's Law Center, I lead our judicial and executive nominations work. So I get to work on SCOTUS nominations, which thankfully we were very excited to work on Justice Delegate Ketanji Brown Jackson's nomination this past spring, which was a direct opposite of the prior nominations I worked on when I was at the Lawyers Committee from the Trump administration. So I get to work on that, and then some cross-cutting policy issues as well, which are focused on democracy reform, which I think is kind of front and center for a lot of folks based on what's going on right now in the world. So looking forward to chatting a bit more with folks. And did you want us to share about pro bono related to our work too, or sorry?
I think we're going to get into that
Okay.
Once we've warmed up our listening brains.
Okay, great. Thank you.
And let's move now on to Tara Ramchandani with Relman Kovacs.
Hi, good afternoon, everyone. Pleasure to be here with you and with these other wonderful panelists. Thanks, Jen. So I'm a partner at Relman Kovacs. We're a civil rights firm with a nationwide practice, but based here in DC or in DuPont Circle. And I have spent really the bulk of my career here at Relman. After graduating from law school, I spent about 9 months at Goodwin Proctor up in Boston, and then went to clerk on the Southern District of Ohio, and then have been here at Relman now 13 years. So started off as an attorney and have been a partner here for about 5 years. So my practice is about, I would say, 80% affirmative civil rights litigation. I have a trial practice, so I have trials all over the country, depositions, development cases all over the country. And then I do a little bit of counseling work while I'll do affirmative civil rights counseling to nonprofits and other groups, sometimes doing sort of employment work and helping them. reform their policies and practices with groups that want to be affirmatively in the civil rights space. And then a lot of firm management. So, making sure that all the frames are running and our attorneys and paralegals are developing, getting opportunities to become civil rights leaders, and that takes up a good bit of my time. So great to be here with you all.
Wonderful. And last, but of course not least, Jonathan Smith, the Washington Lawyers Committee for Civil Rights and Urban Affairs.
Hi, hello, everybody. I'm the Executive Director of the Washington Lawyers Committee. And we're a regional civil rights law firm, so a nonprofit law firm working on a broad range of race equity issues in DC, Maryland, and Virginia, and some stuff all over the country, although it has to have a nexus to the region. And so I have it makes me feel very old to try to go back to do this, Jen, to talk about my career. Like Jim, I've had a lot of jobs. I started actually in a very small 2-person civil rights private practice in Northern Virginia in the 1980s. Helped start an organization called DC Prisoners Legal Services Project, where we did litigation on behalf of District of Columbia prisoners around the conditions of their confinement. I sort of bounced back and forth between civil rights and anti-poverty work, and I ran the legal aid program here in DC. I spent 5 years in the Justice Department at Civil Rights Division. I taught for a year at UDC David A. Clark School of Law, and then I've been for the last 6 years here at the Washington Lawyers Committee. In addition to trying to be the leader of the organization and do the things that executive directors do around fundraising and managing and what have you, I continue to maintain a practice mostly in the around reforming the criminal legal system, and a lot of that work continues to be in the prison and jail space, but most of it is actually working around police accountability. And I do some work around police accountability all over the country. I'm a consultant to the Illinois Attorney General and their pattern of practice investigations. I did a after action investigation of the death of Elijah McClain in Aurora, Colorado, which we issued about a year ago, and continue to try to highlight the need for fundamental and profound change in the way that law enforcement operates in this country.
Thank you so much. So we're going to have some round robin questions, and I think I'll ask one of you to start with each question, and then please add on as you would like. And since Jim has had the biggest break, I'm going to start with you, word of warning. So interested in hearing from all of you, though, where do you see the public interest civil rights field heading in the next few years, especially considering how much the field has changed due to COVID-19 and the urgency surrounding racial justice issues and reproductive and LGBTQI rights?
I think on the rollback on rights front, I think it's going to require a lot of public interest institutions, pro bono efforts that are looking to expand and preserve our notions of rights. Will be a lot of work. But that work probably means reliance on other forms of attorney that have not been front and center, whereas litigation has probably been a predominant model for some time in many rights movements. I think we're going to have to look to creative lawyering, rebellious lawyering in other ways. I can think of, I sort of glanced at the Vega versus TICO ruling this morning, where Section 1983 actions cannot be used to vindicate Miranda violations. It's just a sign of what's to come. The Dobbs decision will foretell a lot of the backsliding, would be my prediction. But in that, I think we're going to have to look at injunctive and short-term relief work as a driver of other things, as a way to raise public awareness, mobilizing people, mobilizing movements, and less as an instrument to get to a final win once something is appealed. So I think we need to look at some of our legal work as triggers for broader conversations in society. I think we're going to have to look at older statutes. I can think of Section 1981 actions, where the frame of reference is if white men get it and you don't. That's an interesting frame for a comparator, one of the few. So creative constitutional things. We're going to have to look to things beyond what we've normally litigated on. Contracts clause violations, personhood claims for subpopulations or marginalized populations, we've yet to kind of reach personhood. And I think we're gonna have to do a lot of work in our states avoiding lockstep doctrine interpretation of some state rights. They need to not be in lockstep with federal. And we're gonna have to learn to do a lot of legislative lawyering and regulatory lawyering at the state level. So a lot of the places where regional and state entities have been kind of filling that space, I think national partners are going to have to supplement and join forces. So this is new places to do lawyering. And so in ways that we have probably been a little too rusty, a lot of the national groups would be my prediction. And technology, I think technology does wonders, but also presents new problems. I was overseeing an administrative court system in Illinois at the dawn of COVID. It's nearly impossible to have ALJs make credibility and evidentiary calls when you're looking through a tiny screen. And there's a huge chasm, whether by SES status or poverty or age, where there's a digital divide. It just becomes harder to develop the record you need to tell the story, to preserve the components, to make the elements of whatever your test is when everything is done through a little tiny portal. So I think we are going to have to get over our tech phobia and find new ways to show and broadcast humanity and stories through different apps and different technologies.
Thank you, Jim. And Erin, I know that covered a lot of ground, but please add on anything you'd like.
Sure, I completely agree. I think we're going to see a shift. We have an opportunity now, I think, in the field to go a bit more on offense in terms of creating that vision that we want to see the world go in. And I think policy advocacy is going to be a big part of that, and working with organizers on the ground as well, in addition to the different forms of lawyering that Jim shared. I also think, I think privacy in tech is going to be a big issue going forward. I think the way in which we engage with the internet is a lot differently now than it was, in the mid 90s when we first got involved with it, started engaging with it. And I think, the extension of how we think of public accommodations in the public sphere versus how it's going to be viewed online, I think is going to be a big central issue going forward. And I think that the policy advocacy issues and engagement and kind of that broader public education on the ways in which we should have these protections that I think a lot of people don't realize that they don't have. And I think for example, speaking specifically for LGBTQ rights, there have been polling done on whether or not people think gay marriage should even be an issue. And I think when you poll younger Americans and Gen Z, they don't generally think of it as even being they think of it as just being something like, yeah, of course, same-sex marriage should be legal, versus, older Americans may not think that, or people who are aware of the legal fight and the fact that the Supreme Court just decided it, I think about 10 years ago or so. So I think when we think about those issues and kind of educating the public about the rollback that we're going to see, policy advocacy is going to be a central part of that, and engaging the public as well to make sure that people are actually voting for candidates and holding their elected officials accountable for their voting records as well, to make sure that we're seeing the policies and laws that we want for the society that we hope to have.
Thank you, Erin. And Tara?
So I think obviously we're in a moment here where the Supreme Court and our appellate courts don't feel like the friendliest places to push the law and change the law. And but I do think that we have to remember that there is still a very important role for enforcement of rights, right? So we get intakes every single day here, and not all of those cases are deeply important, right? We look at both individual cases and more systemic violations of lending discrimination and appraisal discrimination and algorithmic bias and all of these things. And those are rights that we need to continue to enforce. I think we can't just sort of stand down and say the courts are not where we're going to continue to push change. And at the trial court level, we continue to see wins. So most of those cases are not going to go up all the way. And I think I take a lot of comfort in that, right? Which is that we can continue to push boundaries in the courts and to continue to really ensure that our civil rights are robust because we enforce them. So if we stop enforcing, those rights don't really have all that much meaning. And so I think that's one place we have to just keep remembering to push, and we continue to have wins at the trial court levels. I just had a $5 million punitive damages award in a pretty conservative part of Connecticut for disability discrimination for a group home. And so, you know, those wins are still out there, and we can continue to get them. I think that, so I just saw, I think this week DOJ did a settlement in consent decree with Meta on algorithmic bias and how they're advertising housing. So there's spaces that we need to keep pushing on them. Like what a great result, first of all, and I'm so glad that we're bringing these cases, right? Because we know that I think a lot of people will throw up their hands at technology. So I just want to center that, which is like, oh, it's too complicated. We can't, you know, there's so many inputs. How can we figure out where bias and disparate impact is happening? And it is happening. And so we really need to, I think, pay attention on those fronts and continue to make sure we are not allowing passes just because it is complicated or confusing or you're not a tech person. So those are areas we continue to push. And just on the COVID-19 front, right? Like so many problems in our country, what we're going to see is that the fallouts are going to impact certain communities and vulnerable communities more, right? So Black and brown folks, people with disabilities, people with sort of lower socioeconomic status in this country. So just to make sure that we are lifting up those communities and trying to make sure as we get money out, or we saw with PPP loans, right, or where money is going, that money is going to the communities that we most need to help, and to make sure that we hold us all accountable to watching out for those fallouts.
Thank you, Tara. Yeah, I know I rely on my 14-year-old to unlock my many iPhone features. So, and Jonathan.
Okay, well, I agree with everything that has been said. So, and I'm going to try not to repeat it. And particularly, though, I want to lift up what Tara just said about the need for us to not give up. I remember when I started practicing law in the early 1980s, my boss said to me at that time, he'd been practicing civil rights law for a number of years. He says, you know, we've hit a nadir. For all of my career, the law's been getting more protective of rights. And, you know, this was the Rehnquist Court and Ronald Reagan had just appointed. He says, you know, it's all rights are just going to shrink from now on, and your career is going to be different than my career. But since that moment, we've seen, you know, enormous expansions. The Americans with Disabilities Act. We've seen the Obergefell decision. We've seen lots of, and it is true, the courts have made in many ways with standing and all of these decisions much more difficult to bring these cases. But there's still a very significant impact as lawyers we can continue to make to influence rights. But I think we have to be sort of clear-eyed about the difference between the enforcement and protection of rights and the kind of fundamental change that people are actually calling for around a lot of the issues, you know, in the wake of COVID, in the wake of the murder of George Floyd, even what we've seen most recently after the shootings in Texas and what have you, that the courts are still a very vital place for us to do important work within the rights that are still protected. There are huge problems, and particularly the more marginalized. I mean, I do a lot of work with people who are incarcerated. That gets really hard to do. That we've set up all these sort of obstacles, but there's still things you can do there that I think of in the context of sort of harm reduction. You know, how do we prevent the worst impacts of capitalism and the worst impacts of sort of the white supremacist racist kind of country that we live in through the work that we are able to do. But fundamental change is going to come through, the law has never been on the cutting edge of fundamental change. The law follows what happens in the street. And so I think that as we look forward, we're at a really critical inflection point. I think if you had thought about the opportunity for change 2 years ago when people were protesting after the murder of George Floyd and that summer of wonderful people in the street every day, you would have come to think, well, maybe we're at an inflection point where we're going to influence the courts to save the Fourth Amendment, which has nearly been destroyed by the Supreme Court, save some of the civil rights laws and what have you, and civil rights protections, to a place where the reaction has been so profound, one has to wonder, sort of how this sort of tension is going to come out. And so the importance, back to what Jim said, of lawyers actually connecting with the social movements with which they're working is just indispensable. And that the work we do, not defeat, but actually working in conjunction with and support and advance those movements, not supplant them, but advance those movements. And the voices of people who are impacted by the decisions is going to be critical, because the more we legalize the struggle, the fewer voices get heard, and the more those are voices like us that are trained in the profession that are essentially conservative voices, because the profession is a profoundly kind of conservative institution, even as we do this progressive work. And so I think that right now for me, sort of, I'm not known for being an optimistic person, but the optimism I have is that there was this extraordinary movement that didn't come from nowhere. It didn't just happen in 2000. It came from decades of, or years at least, of organizing in communities across the country, really since the wake of the death of Trayvon Martin. So that when that moment happened, people were prepared. And that organizing continues to happen at that very grassroots level. And it gives me some hope that what we see happening in the courts now, what we see happening in crazy legislatures across the country now, we can reverse that as we struggle in the protest movement and the social movement and in the organizing. And so I think that it's easy, and I particularly given that people entering the profession who are interested in doing work in the civil rights are listening to this call, I think it's important to say that as grim as it looks, there is really levers that can be pulled to change that and to reflect a country that has more aligned with the values that we would all want it to have.
Thank you very much, all. And Erin, this one is coming your way first. So just looking at whether there are any other emerging issues, areas of law that students should be focusing on right now.
I definitely think, kind of going forward, I think the emergence of privacy rights is definitely going to be an emerging field. It's something, if you look at our current Congress, we don't have any committee specifically dedicated to it. And I think that's kind of been why there's been issues with them attempting to address it, because part of it touches like commerce a bit, and then you have the judiciary for the enforcement of civil rights, for example, with thinking of privacy rights as civil rights. And you have the banking committee that likes to look at it as well for the privacy issues related to regulatory and financial matters. So I think that's an emerging area for current law students to kind of look into going to, because I think as we shift, especially like our political bodies as well, it's going to be a shift to having them focus a bit more on privacy information. And I think when we look at all of the disinformation that we see, for example, on Facebook and Twitter and other platforms, that's a huge issue where it's been difficult for lawyers to kind of navigate how to address that using litigation, for example. So I think that definitely is an area for policy reform. I also think an emerging area we're going to see is broader democracy reform as well. I think we've seen kind of silos of issues within civil rights in terms of thinking of voting rights and reproductive rights access, for example, and with educational opportunities. And we've kind of seen that the rolling back of a lot of those rights separately. But I think when we take a step back and look more broadly, I think what Jonathan was kind of sharing a bit about with his story and earlier in his career, hearing that the rights were going to start to be rolled back a bit. I think when we look at them as a whole, then I think when we look at broader democracy reform, like what kind of reproductive rights and health access do we want our citizenry to have? What does voting rights look like for everyone? What do educational opportunities look like for everyone? What do employment opportunities look like for non-discrimination? What does adequate housing access look like for everyone? And I mean that within broader democracy reform. So I think for folks entering the legal profession, kind of thinking about the full picture for what does our society look like? What do we need to address? What does an ideal American life look like? and like legally, what are the legal protections we can have and put in place? What does that look like from a policy standpoint? What does that look like from litigation, from enforcing those rights as well? I think those will be emerging fields that we'll see in the civil rights field versus seeing more of the silos that I think we've seen traditionally over the past 20 or so years.
And Tara, Jonathan, Jim, if you have anything to add to that, please do.
So I think that's all right. I think I have three things that come to mind in terms of sort of legal doctrine and places to be pushing. So one is unqualified immunity. I think we're in a moment where, you know, it's an issue that is gone from just being kind of more of an esoteric legal question to something that is gaining traction in advocacy communities and sort of grassroots work too. But I think we can make movement there in terms of expanding what, you know, where you can bring causes of action against government actors and the police. And so continuing to push there, I think there's a lot of opportunity, and we just need to keep trying to narrow the times when there is protection granted on qualified immunity grounds. So that's one place. Another, and I think we've seen a lot of great movement from state legislatures about source of income as a protected class, right? So not allowing discrimination, particularly uses a lot in housing and lending, but based on, you know, on your source of income. There are a lot of landlords out there who won't accept vouchers or other government assistance when you for housing, and just there are states that have this protection. I think we can continue to push. There are ways to do it through federal laws, but paying attention to state protections and state laws on that, and that's a place I think it makes a huge difference, and we see a lot of it, a lot of discrimination based on source of income. And then on the last piece, and Aaron spoke this a little bit, but the technology and accessibility, right? So the ways that we have accessibility on websites, I think we have the technology capabilities there, and so we just need to keep making sure that we are viewing that as a space of public accommodation. And so that's the other place I'd say that I think we can make a lot of progress, and people really need to be paying attention. Sorry, I had one more as a fourth. You know, just thinking about mental health and mental illness as part of disability protection, right? It is a huge. I mean, 1 in 4 people at any given time in this country are grappling with a mental health disability, and making sure that as we are talking about disability and accommodation modification, that we are including it as part of our language and work on disability.
If I could just add a couple of things to that. I'm glad you raised qualified immunity. I think that I think there is some opportunity to, and some of the courts of appeals have narrowed qualified immunity surprisingly, and there's even been support amongst the conservative justices to think about how to address qualified immunity. Thomas, of all people, who's said, why do we have this crazy doctrine? Shouldn't we get rid of it? But I think that there's far too little attention paid to its evil twin of Monell. Qualified immunity, prevents you from getting damages. It stops you from being able to recover compensation. Monell, which is for those, people on the who are not yet lawyers, is a doctrine that says that you can't hold a municipality responsible for the misconduct of its employees. Like you might, if a business, you could just hold, under sort of an agency or respondeat superior theory, responsible, unless you can prove that it was a cause of a decision maker, a final decision maker in the agency, or a policy or practice of the agency, which means that much of the misconduct that we know to be systemic and we want to try to address is beyond the reach of the federal courts to address. And so in some ways, I think Monell is not only the evil twin of qualified immunity, it may be its eviler twin of qualified immunity, because it's an ability to address, allows us to address changes to the way that government functions, and in addition to not being able to get compensation for people who are harmed by those practices. The other thing I just wanted to raise is that we've had a period in the last 50 years of incredible growth in mass incarceration of Black and brown people, and in addition to the real work that's underway to try to reduce the front end of people getting caught up in the system through police reform, prison and jail reform, and what have you. There's the issue of the impact that those convictions have, the incredibly disparate impact those convictions have on people of color. And we've done a lot of work. I know Relman's also done some work in this area on the impact of a criminal conviction on housing, employment, access to credit, access to an education. For example, when during the CARES Act was passed during the height of the pandemic, and there was payroll protection loans that were available, and through the Small Business Administration. The Small Business Administration promulgated a rule that if you had most criminal convictions prevented you from being able to get a payroll protection loan program, which had a disproportionate impact on Black and brown business, particularly small Black and brown business. And one thing we saw from the data from the pandemic is that there was a lot of business loss, but the vast majority of it was small businesses owned by Black people. And the data is like unequivocally. And we ended up suing the Small Business Administration, and the court found that that rule is arbitrary and capricious, but it ended up getting reversed at the very end, and a lot of businesses never got to take advantage of it and what have you. And that's kind of discrimination we've got baked into our economy already, de jure policies that have created this inequity both in wealth and in income. And those kinds of policies just, because of the operation of our criminal legal system, bake that further into the system. And so this whole area of being able to fight against the impact, the lifelong sentence that a conviction may have on you for participating in the economy, I think is an area of real tremendous opportunity to make a difference. It doesn't quite get to reparations, but it's got a kind of a reparations sort of theme to it that you can strike that I think can make a real difference as we move forward on important advocacy.
I'll just offer two thoughts, two concepts that I think are important to hold close or keep in your mind on your way to law school, during law school, and particularly once you get a law license and after law school. I think history matters, and I think seeing opportunities for agency within the law, agency for your clients, are particularly important. My first 10 years of practice was with not exclusively, but by and large, with the Mexican American Legal Defense and Educational Fund. We are at the 40th anniversary of Plyler v. Doe. That Supreme Court decision essentially guaranteed undocumented youth access to K through 12 education. And so I can think of my first weeks on the job as a baby attorney to later in practice. My clients really embraced Doe status. They were the Doe in Plyler v. Doe all those years later, to within one generational cohort to going to undocumented and unafraid. It taught me a cautionary lesson. It's not for high impact legal organizations, it's clients have different things in mind and different priorities for their lives. So the ability for one movement to pay attention to another movement, here, immigrant youth paying attention to queer liberation actions led to a whole host of other lawyering problems from a lawyer's perspective, but incredible opportunities for young people to move forward. Today, those opportunities are DACA clinics, people applying and maintaining for that limited relief from a federal agency. For gender nonconforming populations, it's name change clinics. All of these little opportunities for people to use the law to further their lives, to grab a hold of something, to have a little more permanence, are not to be sneezed at. But pay attention to clients and movements, and whether you're on your way to law school or in law school, supporting those beyond law spaces are important because there's lots of potholes there. Engaging in building community across digital spaces raises a whole host of legal potholes and dangers, but also incredible power. Media training, having people engage in toolkits and apps to help themselves access process is a bit of could create problems with unauthorized practice of law, but it's also empowering. So there's just a whole host of things that can be done, but paying attention to clients who are looking for an intersectional approach to the law, where they are centering race, where they're centralizing LGBTQ plus status, and making sure that whatever that movement is and whatever legal challenges they face, it leaves people with more collective power, and it's less about the court win or the congressional victory or an administrative win. It's about standing in community and demanding power. So history and opportunities for agency would be my 2 tips for what to pay attention to on your way and during law school.
Thank you. And I do see a question here now, and I wonder if it might make sense on the heels of that to pose it. Although, let me do this, given our time. I want to acknowledge the attendee, and I will make sure to get to that as our first post question. I think we've all, Erin in particular, and all of you addressed intersectionality to some extent. So I'm going to move to some particular areas of interest for students now, and then we may come back to that. So Tara, I'll ask this of you first, and then round robin to add on as you would like. Some students who are really interested in the civil rights field might still have to start out in big law for financial reasons and then pivot to public interest work later. What advice would you give to someone who wants to take that path?
Yeah, so I started in big law for a little less than a year, and so this is a good question to throw my way. I think the most important thing is to keep centering sort of advocacy and public interest work at the heart of what you're doing. You can do that, and just like don't like take your eye off the ultimate goal of the work that you want to be doing. So there are a couple pieces of advice that I got that were invaluable. So one is, if the answer is, you need that income, make sure that you're planning for a public interest salary down the road. So what we did was we lived off of what would have been our public interest salary, and the remainder of that money went to loans. And so, just don't sort of expand. You can always expand your budget to fit whatever your income is, I think. And so don't allow yourself to do that. So really be very disciplined about sort of how you are setting up what your monthly expenses are, where you're living, and all of those kinds of things. It makes a huge difference. It's very possible to do, but I think you often people say, well, how am I going to take that large of a salary cut? And if you're living off of what you're eventually planning your salary to be, then it doesn't feel like a cut once you make the move. I think, if you are centering pro bono work and taking any opportunity you have to get involved both outside of work and then within the firms, right? So all big law firms do have a pretty active pro bono practice. So get to know the pro bono coordinator and really focus on that work, right? I think there's a lot of pressure internally, right? I think the law is sort of tends to hierarchy for worse often, I think. But at a big law firm, there'll be a lot of pressure to be filling those hours, to be working with the partners who are sort of the rainmakers, and you kind of have to put that aside, right? If your goal is not to become a partner at a big law firm, and your goal is to ultimately be in a public interest place, then focus on that, right? Do good work hard, but don't be trying to chase the same brass rings as the rest of your classmates if your ultimate goals are different. And I think also you have to keep networking and keep making sure that you're working and paying attention to these issues. So one thing that won't work, right, is to spend 5-6 years head down just doing sort of the traditional paid work at a law firm, and then to say, and now I want to go into public interest, right? So you have to make sure that you are developing those skills and paying attention to the issues on the ground and being involved in community throughout. So that's my advice.
I would add to that is doing pro bono and volunteering in the areas that are of interest to you. So if you get the opportunity to do pro bono, if you're interested in working on housing cases, for example, is to try to find pro bono housing opportunities that you can work on, whether or not that's direct services or whether or not it's for a nonprofit that's doing impact litigation. I know that we at the National Women's Law Center, we use pro bono often for our Supreme Court research, for background research on candidates too. So that's another area where if you're interested in working on judicial and executive nominations, or just kind of broader judicial strategy, I know that we definitely love having pro bono support for that and getting engaged. A lot of nonprofits also have separate committees that folks can get engaged in when they're working on the in the pro bono. Sorry, when they're working at a big law firm, so that way they can kind of get engaged with the work of the nonprofit, and get a sense of if there are any opportunities for them to advise or work with attorneys at the nonprofit as well. And also reading up on the cases and policies in the particular field of interest to you, so to make sure that you're just kind of staying up to date on changes in the law and just kind of as things are moving. So that way, if you do, as you prepare for your transition, and start networking and interviewing, you at least have that knowledge base that'll be good to take with you. So I have been in public interest for the bulk of my career, but I did have a lot of friends who I went to law school with who did go to big law initially and then transitioned into the nonprofit world after 4 or 5 years. And I've also worked with attorneys who transitioned from big law into the nonprofit world as well. And I think one of the biggest aspects that they were grateful for was just doing that pro bono and volunteering, also getting involved with Washington Council of Lawyers and other local bar associations as well, with their special committees and other groups. And I think networking is a huge part of it, and you want to show that you've had an interest in the particular area as well.
I think that's all right. I mean, when I look at a resume from someone who, is applying for a job, a demonstrated commitment is really important. And so doing the pro bono work, serving on a board, volunteer service, whatever it might be, that really shows that this is what you want to do. The only other thing I'd say is that it's not a binary. The profession has actually lots and lots of ways to practice law that are really important to people who need lawyers. Small or not so small plaintiff side law firm, civil rights law firms can, make an enormous contribution. A small practice that serves the needs of people in a community that just generally need lawyers to survive can make a big difference. And so it's not a binary between coming and working in a nonprofit or working in a big law. There's lots and lots and lots of really great ways to give back to communities, to advance civil rights, to advance public interest principles. And so people should be open to wherever you are, wherever you land, the ways in which you can really make a difference and contribute.
I'm sorry.
Listen, I will just lift up one quick thing. I think in those opportunities of someone who's at a firm and has opportunities or paths to within that firm to do pro bono, there's a multitude of places those services can be deployed. So think carefully of whether direct representation is a wonderful thing to have. Providing alliances and cooperating attorney agreements for national entities that are looking to maybe do defensive work in a particular state you might be in is another wonderful opportunity. But the tip I would say from the nonprofit law firm perspective, while you're complying with all of the big laws rules about pro bono, pay attention to how your cooperating attorneys in the nonprofit sector and the different customs and the different norms they have. I can think two of the most impressive high impact litigators I know of graduated from starting with pro bono services to eventually becoming movement leaders. So pay attention to how you partner, how you are go above and beyond. So meet the formalities of big law requirements, but also think of your nonprofit folks if you hope to one day to cross over into nonprofit practice. So if that is your goal, pay attention to kind of succeeding and building alliances and networks on both sides of those the same rules, but different presentations of lawyering in both different routes, the big law setting or the for-profit law setting and the nonprofit law setting.
Terrific. Thank you all. And remember to look for the folks like me at your law school, if you have one, or other folks who are going to help you connect with community organizations doing this work. And interested now in whether there are, to full circle back, and then we'll get back to the particular question from an audience member, that are there particular pro bono opportunities in the civil rights field that you'd recommend for students to get involved in now while they're still in law school, and perhaps with your organization specifically? Let's start with Jonathan on that one.
2 years in the pandemic and I still can't find the mute button. Yeah. So there's a myriad of ways to get involved with us. Right now, for those who are Rising 3Ls, we've got accepting applications for fellowships. So go to that seminar, but don't wait to let us know if you're interested. And I think throughout the sector, there's lots of really great opportunities for people to apply for fellowships. We throughout the year have law interns and undergraduate interns our undergraduate interns do a tremendous amount of really important work in our prisoners' rights practice in terms of helping us respond to hundreds and hundreds of email or letters from people who are incarcerated in the Federal Bureau of Prisons. So, think about ways to get involved. We operate as part of our workers' rights practice. We have a weekly clinic where people come in around wage and hour and discrimination and collateral consequences in other cases. And we forever need people to help with that intake process. We see hundreds of people every year. And the front line is very often law students who will spend time with us, helping us. And from that practice, not only do we provide direct service where we are help people solve their problems, but we identify issues for systemic litigation and use that as a tool to do that. For people who are maybe associates in law firms, please take a case. One of the things that has happened in the last few years, and I think we saw it in some reporting in Above the Law or one of the other legal journals, is that law firms have actually shrunk in the last few years. They've become vastly more profitable, but they have far fewer people. And so it's becoming harder and harder for us to identify people to come and take cases with us because of the pressures of the law firm and the higher pressures created by the higher salaries and everything else. So please, if you're in a law firm, if you're an associate, you're interested in taking a case, let us know. We've got systemic cases that are modest. None of them are small, modest. And we have systemic cases that are quite large. And we really look forward to having people join us and to be able to help us pursue those, because our staff cannot do those cases without partners throughout the legal community who do them. So whatever meets your needs in terms of, you want to do just a few hours a month, come work on our clinic. You want to be an intern, you want to apply for fellowship, you want to take a case, we're ready to work with you to try to find the right place.
I just want to highlight too, while there are many external third-party fellowship routes as a way to kind of partner with a sponsor for a nonprofit law firm or a nonprofit litigation-centered law firm. There are sometimes internal fellowships. So I just wanted to point out and elevate too that Lambda Legal has found funders to underride. We have a Renberg Fellowship that is for an attorney to join us in our Western Regional Office in LA and focuses on LGBTQ+ litigation and policy advocacy in the Western region of our country. And separately, we have the Garner Fellowship, which is focused exclusively, can be in any one of our offices at Lambda, but it is for those who want to focus on a docket that is focused on African American LGBTQ plus rights. So it is a race-centered queer rights portfolio. So there are ways to pitch a project, but sometimes our nonprofit organizations, Lambda included, have their own pitched placements for short-term entry-level positions that you should not blow past. You should take a closer look at. I'd also point out there are opportunities that are not purely in the performance of law, but they are available. At least I can point the ones out in the LGBTQ plus movement that are available and could use everyone's efforts. So not just law students or young lawyers, but all of us here today. A lot of the marginalized folks we represent at the margins in the shadows, there's not a lot of available data. So on those occasions, some of our nonprofits, including the legal ones, are doing data collection or survey efforts, partnering with appropriate statisticians. We need everyone's help to lift that. I can point out to a sibling organization, the National Center for Transgender Equality does try to pull really robust and textured data on all gender nonconforming folks across the country. There's a survey for that is live. At the same time, Lambda Legal and Black in Pink, we're promoting a national data collection effort. We do it once every 10 years about queer folks' engagement with the criminal justice system. So we'd welcome every one of you taking a few moments and pushing out the survey link and getting anyone who identifies as LGBTQ plus to report on positive, negative, and horrendous stuff that befalls them at any point in the criminal justice pipeline. So there are those sort of efforts that are kind of short-term, but really important data collection efforts that inform eventually reports and filings in courts, reports that then become things in front of legislators and regulatory bodies. So efforts to collect and promote data is something that I would put on the horizon.
And I'd add doing like legal externships during the academic year as well. I think it's a good way to earn academic credit, and also even if you're interested in going into big law immediately after, it's still a way to, demonstrate that interest that you have in working on a particular issue in the nonprofit world if you do intend on working in public interest down the line in your career. So definitely echo that, and doing pro bono, doing clinics at your law school if those are offered as well, connecting with the pro bono coordinators at your law school to find out about those opportunities, to also work in direct services as well.
And I'll just add that we also have a internal 2-year fellowship. So I definitely encourage anybody who's interested to apply. It's a 2-year litigation fellowship. We'd love to see your application. Usually opens in the summer.
Wonderful. Thank you all. And I know we are getting tight on time, but I think in the interest of being responsive, I'm going to go ahead and ask these questions. If folks do need to jump off, you know where to find us for any follow-up. So the first is, in light of anti-CRT legislation and rising support for the belief that there is a threat to whiteness, how do you recommend addressing systemic injustices and/or racial disparities? And I put that out to the floor.
I'll take a crack at this. The beauty of critical movements, including critical race and queer crit and femme crit and lat crit, et cetera, is it challenges us to disrupt the boxes that the law enforces on us. So in the performance of attorneys and creative pleading and creative argumentation, we can learn a lot from critical movements that doesn't force us to always check off the obvious counts in a complaint. We can get really creative. Separately, what part of those movements are deeply rooted in across discipline is deeply understanding our history. So to the extent we are looking at critical race bans as a way to whitewash history, the legal academy and lawyers, we have stories to tell. We have facts that aren't debatable. We have moments in history. We have statements in passages of horrible pieces of legislation that are still on the books. So there's a way we can root history in all of our legal work and force those questions before courts or other forums that are making, whether it's legislative, et cetera, forcing and censoring the fullness of history, and whether it was the intentional bias that existed in the day and that there's a record of, or the impact that carries through to today. So there's importance of not being too taken aback by the critical race bans, but leaning into it as a response and recentering history. It's just choosing a different label in how we perform as lawyers.
And also, I feel like whenever I'm asked about the anti-CRT things, I always think, it's not, they're not banning critical race theory. It's not something that's actually even taught in public schools. What they're actually banning are basically books that are by people of color, that are authored by people of color, and that are focused on characters that are people of color. So I think framing it as that and kind of educating folks on what it means to actually ban books by Black authors, to ban books by Hispanic authors, what that says when you're only allowing in books that are authored by Caucasian Americans. And I think that when you have that sort of conversation with folks, it kind of opens the door for them to kind of hopefully see what it's doing. But critical race theory is it's a legal theory that's taught in law schools, and some people learn it at the undergraduate level if they take a course or two in it, but it's not something that's taught to students in school and K through 12 education. So I think, understanding that we're excluding amazing authors and amazing poets and books about the full American experience and a full American experience is a diverse experience, if we're being honest about that. So I think we have to have those conversations about folks and make sure that they understand what's actually being banned, because we do have a lot of fear mongering on the end for what's being taught. But like a book by Toni Morrison is not critical race theory in a sense. It's a book by Toni Morrison. That's amazing work, an amazing author.
Well, thank you, Tipo. Jonathan, did you want to jump in?
I don't have really much to add. I think it's really important. But I do think that the truth-telling role that we can play is really important, which is really just to underscore what both Aaron and Jim had said, that this is all a bunch of lies and it's trying to hide real history. And this idea that by talking about the fact that we had slavery and the legacy of it, and lots and lots of other ways in which we have, both in official and cultural ways, committed horror, and that will somehow upset white children is just, it's just like this kind of appalling, bizarre world to live in. And for us to just continue to tell the truth is the only thing we can do.
Okay, and one other question here is directed to the panelists who worked in government positions as well as nonprofit positions. Would you please describe your experiences in each position, such as autonomy, ability to effectuate change, funding limitations, and your ultimate decision to choose one over the other?
I'll jump in. Oh, Jim, do you want to go first?
No, go for it.
Okay, so I mostly spent most of my career in the nonprofit sector, and in one role or another in civil rights or anti-poverty organizations, some direct service, some impact work, a lot of combination of both, and then had an opportunity to join the Civil Rights Division in 2010, and to go work on a series of cases and projects around mostly the ways in which governments interact with either through the criminal legal system or the confinement of people in institutions because of their disabilities, and was the chief of the special litigation section in the Civil Rights Division. And while I think it surprised everybody at the time that I went into government, and it didn't surprise anybody when I came out of government, because I don't color in the lines very well, and playing by the rules is not particularly good, and I'm not very good on hierarchy. I am incredibly glad that I did it and the experience that we had. I mean, we were able to make real changes in the way that the Civil Rights Division approached, particularly in our policing work, but also in our prison and jail work and in the work around the way that we applied the Olmstead decision, which I think it's like the 36th anniversary of Olmstead today.
Yeah.
So I was incredibly glad to have done it. It is actually extremely different to be able to what you can and cannot do in government. When you're in government, you have an enormous amount of power and authority and resources that you don't have in the nonprofit world. People come to meetings with you because you're DOJ. People want to have meetings with you because you're DOJ, that you don't have in necessarily in the private sector. You can hire experts when you need them. You can travel when you need them. There's lots of things that you can do, but it's also the fact that you're going to be playing within the rules of the institution, and these institutions are, they tend to be fairly resistant to doing something differently than the way it's ever been done before. And so, you've got a lot of power to do things within the limits of what you have the power to do. So when we were doing policing accountability work, we had the authority to address patterns and practices of the violation of the Constitution and federal law by law enforcement. Well, there's a lot of things the Constitution allows police to do that are really terrible and that we don't want. But that wasn't our jurisdiction. Our jurisdiction took us to the edge of what the Constitution permits. And so there's that limitation. There's also the limitation that we were doing reform around prisons and jails inside an institution that was also the largest prison system in the United States. And we would run up against the Bureau of Prisons all the time, or we'd run up against the institutional concerns in our policing work of the FBI or the DEA or what one of my colleagues used to call the components with guns. Would always be our opposed. So there's a tension and there's a balance. And I have lots of friends who remained as career people in the federal government. They're doing enormously important work within that paradigm. But it is within that paradigm. You're not pushing beyond what the limits of the institution will allow. So I encourage people to do it. I'm so thrilled that I did it. I'm glad of what we were able to accomplish when I was there, but it's a lot of hierarchies, a lot of barriers to change. And you run squarely up at some point to the limits of what the institution will permit.
All of that, all of the above, everything that's just been said. I think if you are going to be a movement lawyer or you are going to take on public service, it only helps you and those you represent eventually to have the perspective of both outside and inside. So if there's an opportunity, whether it's career or whether it's political appointment into government, I would also highly recommend time in state and local government. I've done all. It helps you understand how institutions, the churn and the bureaucracy within them, where true decisions are made. It only gives you more context for when you're back out in the advocacy world to pick up on subtle cues or to read the public record to find the smoking gun thing that is a bellwether of what's to come. And the one tip I would learn from both perspectives, if you ever get a call from someone in government randomly asking you to make time, they're doing you a courtesy. They are pointing out that the major decision is about to be made. And I found myself in government calling stakeholders that my career staff had no conception were stakeholders, and asking folks to come in without explanation. I couldn't flag or signal, and just sort of really emphasizing, please come in. And I could not, it appalled me how many advocates would not come in because they had other priorities or they were busy. So there's a way to look at how the soft centers of power within a bureaucracy turn. So if you can, some time in government will only help you be a better advocate in the long run.
I agree with both of what Jim and Jonathan shared. I do want to add a caveat that I do think your ability to effectuate change is going to be based on how senior you are. at a lot of organizations. So you'll definitely still see a bit of the bureaucracy at nonprofits and in the nonprofit world and the hierarchy as well as you're starting out in your career. So it's definitely something where, you know, as you gain expertise and as you build on your management skills and kind of move up the career ladder, your assessment of the organization is going to change depending on where you fall within the hierarchy for what you're able to change or anything, or in terms of pushing for the sort of opportunities or the portfolio of work that you'd like to have as well. For example, a lot of nonprofits are funded by grants, and those grants will determine, you know, the scope of the work and the type of litigation that can be brought and the type of policy advocacy, like what sorts of briefings. It depends on how detailed the particular grant could be. So while there is some flexibility on some end, it is going to be contingent upon how senior you are within your respective organization too.
Wonderful.